I'm sorry. Go ahead. So your testimony is that you did have authority to conduct the deal, or you think you could have gotten authority to transact the deal when you offered it?
The development manager told me to move forward with the trade.
Okay. Did you tell that to Powderhorn that it was a soft offer?
I told them that I could move forward and we were, I think I said scrambling.
Okay. And in your opinion, does these, and I know it's hard to make deals and you got to convince a lot of people, but I guess what I'm struggling to understand is how is that substantially different than the behavior you complain of for Powderhorn?
We own the acreage
Sure, but you
that
didn't
we
have
were
the-
going to trade. Sorry.
my temptation is to engage like it's a conversation, so I apologize to the reporter. I think we've made the point. So if we go on, so we talked about the second, there was a meeting, it's canceled. The fourth, there's a soft offer. And then on the 6th, so we're like 4 days. The day that the deal was pulled from Powderhorn, they informed you that the deal was off the table. Is that correct?
After I asked them about the ownership.
But they contacted you or at least communicated to you 4 days later from this whole transaction that the deal was no longer available. Fair?
After they admitted they didn't own the acreage.
Correct. And just, I apologize that this is repetitive. Did you convey that you had soft consent authority only and not actual authority to make the offer?
I did not misrepresent our authority or approvals.
Sure. You didn't misrepresent it,
Correct.
but did you represent that it was only a soft offer?
I don't think I used the word soft. It wasn't a soft offer.
It wasn't a soft offer? I
don't-
thought you characterized
I
it.
said soft consent.
I think we're getting into semantics. Is okay. But then you go on and say, so you find out on the 6th, they don't own it, deal's off the table. And in your testimony, this terminated your negotiations. But you did continue to negotiate after that time. Is that fair?
That terminated the trade negotiations.
Okay. Let's go to paragraph 27.
Mhm.
That revelation terminated our negotiations. Is that your testimony?
That is my testimony as it relates to the trade.
As it relates to the trade? Okay. So then time goes on. You represent, you're having a meeting on February 18th to decide on carry offers and go forward plans. Is that right?
Yes.
Did that meeting ever actually happen?
That meeting did not happen. I met with the development manager separately and my manager.
But you didn't tell Powderhorn until the 20th that you were no longer interested in a mutual agreement. Is that correct?
If that's the date,
That's a yes.
that's the date of the email.
Okay.
Is it?
Yes, that's the date of the email. Or that's the date that Powderhorn's testimony states that they were informed that you were no longer pursuing a mutual deal.
So what's your question and has there been an answer? Because I haven't heard the answer.
I think we're getting bogged down. I'll just withdraw the question. I think it's that
Fine.
important. So up until that February 20th timeline, it would have been reasonable for Powderhorn to conclude that negotiations were still in progress. Is that correct?
What type of negotiations?
Hold on a second. Please don't ask
I'm sorry.
him. If you don't understand the question, just say you don't understand, but please don't ask him questions.
Yes, sir.
Would you clarify your question? Because the witness doesn't understand.
Let me see if this is more succinct. So you guys sent your 1 mile well proposals to Kaiser Francis on February 12th. Is that right?
Yes,
8 days before you told Powderhorn the deal was off?
if you say so.
And that would have been 6 days before the scheduled meeting?
I'm sorry. Hold on, Mr. Holliday. Ms. Klingler, please just answer the question. If you say so is not an answer. Okay?
Yes.
So ask your question again, Mr. Holliday. I want a clear answer to the question.
Kaiser, you sent Kaiser Francis their 1 mile proposal on February 12th. Is that correct?
That's correct.
That was 8 days before you told Powderhorn you were no longer seeking a mutual agreement. Is that correct?
I believe that is accurate. I don't know the exact dates off the top of my head.
And then that was at least some days before the meeting that was supposed to happen on the 18th. Is that correct?
I'm sorry, what are you referring?
You sent your 1 mile proposal a week before you had this meeting to discuss Powderhorn's offer. Is that correct?
Yes.
But you didn't send the proposals to Powderhorn until March 2nd, 8 days before the hearing. Is that correct?
That's correct.
So you were pursuing a 2-track negotiation. Is that fair?
I didn't send the Powderhorn proposals until March 2nd because I didn't find out until February 27th that there was an interest that they owned in the North Havasu, subject to our operating agreement.
But you were making proposals to Kaiser while also talking to Powderhorn. Is that fair?
Yes,
But did you communicate that that offer had been made, or excuse me, the proposal had been made to Kaiser Francis?
I'm sorry. Can you be more clear?
No, withdrawn. I think I asked that question already. So part of the objection that you voiced to the plan was that Powderhorn had informed Marathon it would need to rely on Marathon's takeaway. Is that a fair summary of your conversation?
That was in an email.
That was an email. So that was in the midst of trade negotiations. Is that accurate?
I'm sorry, say that again?
That was in the midst of trade negotiations. Is that accurate?
Yes.
And did Powderhorn respond to your questions about dedications that it would be open to reviewing your contracts as part of an agreement?
Yes.
Do you have any direct or personal knowledge of Powderhorn's conversations with third-party midstream providers?
Only what they told me in the emails.
So yes or no, do you have any direct knowledge of Powderhorn's conversations with third-party midstream providers?
Yes.
You do have personal knowledge of their discussions with third-party providers.
Because they told me
What did they tell you?
that they had water and that they were working on crude and gas.
Okay, but you don't know how those, you don't know the substance of those conversations, fair?
No,
And so they told you that they had entered into a water disposal agreement, is that right?
yes.
And in your role as the landman in charge of this area, or the north half of section 2, are you responsible for managing takeaway commitments as referenced in your testimony?
I'm sorry, can you restate that?
Are you responsible for managing the takeaway commitments from a land perspective in this area?
There's a commercial department that's in charge of takeaway commitments. So I, as the landman, am not in charge of takeaway commitments.
So you wouldn't be the right person to talk to about Conoco's takeaway commitments or capabilities. Is that fair? I would need to talk to somebody else.
I'm aware as to this area because I communicate with the commercial department.
Okay. Who are your midstream counterparties under your commitments for this acreage?
We are not allowed to discuss that. We have to sign confidentiality agreements.
So
with
it's
the
confidential.
midstream.
Okay, that's fair, because I think both sides have withheld confidential information. You testified on March 4th that Powderhorn does not have a pre-approved state communization agreement. Is that correct? In paragraph 24?
When I stated that, I was not aware that they had submitted for pre-approval.
Okay, so fair to say that is no longer an accurate statement.
Correct.
If we talk about the bat bomb a little bit, I want to talk about from an experience angle. Had you ever so we had the canceled meeting. Did you ever meet with the technical staff at Powderhorn?
Can you define the technical staff?
Did you meet with anyone other than Travis Maka and Mason Maxwell?
Yes, sir.
Who was that?
Their co-CEO, Jack Yates?
Jack Yates. Okay. Did you meet with any of the engineers at Powderhorn?
No, sir.
You didn't? Okay. So at the time you guys signed the bat bomb and war pigeon units, I think we can agree Admiral Permian had never drilled a well. Is that right? In New Mexico.
They had not drilled in New Mexico.
Okay. And that's the same criticism you're leveling today at Powderhorn. Is that correct?
Not entirely.
How is it different?
We were familiar with Admiral already because of a project in Texas that they were drilling.
And do you contest that the members of Powderhorn, they drilled wells in Texas also in their prior experience?
From what I've seen, yes.
Okay, move to that. In paragraph 19, you criticize Powderhorn for not having an in-house drilling team. Does Conoco use third-party drilling contractors?
We do use several contractors. We have an in-house drilling team.
And so we don't have to pull up the exhibit, or we can if we need to, but if we were to look at the AFEs for the Campana wells, we would find multiple entries for drilling contractors. Is that right?
Yes.
So is it fair to say the Powderhorn's use plan, or excuse me, stated plan to use a contract drilling operator or contractor, is that consistent with standard industry practice, including COP's own practice?
I don't believe that's entirely accurate.
Do you believe that Powderhorn's plan to use a contract drilling contractor is consistent with standard industry practice?
To use contractors, yes.
Do you understand that Powderhorn seeks to acquire, from Mr. Maka's testimony, do you understand that Powderhorn seeks to acquire non-standard locations prior to spud if it's granted an order?
From what I've read, yes.
But you guys are not seeking any sort of non-standard location. Is that accurate?
We're staying in the setbacks.
So if you're staying within the setbacks, given the difference between 103 to 130 feet, is it fair to say that then at a minimum, 460 feet of perforated lateral as to each well will be forfeited under Marathon's plan?
Objection. Powderhorn needs to get that approved from the division, and there's a pending objection. So trying to compare the difference between their laterals and as proposed and Marathon's is subject to administrative approval, likely to go to hearing that hasn't been done yet.
Okay, I don't disagree with what you said, but what's the objection based on?
Well, the question is, I guess, going to a hypothetical. So I guess if Mr. Holliday could phrase it as a hypothetical, then that would be a more appropriate approach to asking the question.
Mr. Holliday?
Let me try it this way.
Rephrase your question?
Yeah, I'll rephrase.
Go right ahead.
So not talking about Powderhorn, talking only about Marathon. Given that 330-foot setback rule that you intend to stay within, is it fair to say that at a minimum 460 feet of perf to lateral as to each well will be forfeited?
No, I don't think that's fair to say. Since we're staying within the pool rules, you're not forfeiting anything because we're following the rules?
There would be 460 feet less lateral length per well than if you did obtain non-standard locations. Is that fair?
I believe so.
So in a hypothetical situation in which Powderhorn did obtain non-standard locations, that's going to add an additional 100 feet, making it a total, well, that's a question for your geologist. Okay, last thing. I think we've heard some testimony from you earlier that Powderhorn has various options to develop its acreage. Is that fair?
Yes,
And you're testifying here as a landman today, is that correct?
yes,
And you're not a reservoir engineer or a geologist, is that right?
correct.
Okay. And you don't have any educational background in either of those disciplines?
That's correct.
And you haven't been qualified by the division as a geologist or engineer?
I have not.
Fair to say that Marathon doesn't ask you to perform those functions?
That's correct.
Maybe some closology? So if you're not an engineer, you're not qualified to testify before the division. Other than the literal physical possibility that they could go north-south, what is your basis for stating that Powderhorn has multiple viable or economic options to develop its acreage?
I consulted with the subsurface and drilling teams.
Okay, so in paragraph 17, you testify about parent-child degradation effects within the Wolfcamp Formation. You wrote that testimony, is that correct?
Yes, that was based on my conversation with geology and reservoir engineering.
Does paragraph 17 reference a conversation with a geologist or reservoir engineer?
I'm sorry, what are you asking?
Did you reference in paragraph 17 that you had consulted with a reservoir engineer or geologist?
No,
You testified that parent-child degradation occurs and you talked about it in your own testimony, fair?
yes,
In this same paragraph, you state that, I'll highlight the language. We're almost done. You state that incremental reserves are going to be left behind by not co-developing the Wolfcamp A on the south half of section 2 and the east half of section 3 with the north half of section 2. Do I have that right?
I'm sorry, can you repeat that?
Yeah, let me just read from the exhibit. Your testimony is that unlike Marathon, Powderhorn's approach will result in parent-child degradation effects within the Wolfcamp Formation, causing waste and impairing Marathon's correlative rights by preventing Marathon from capturing these incremental reserves. Is that an accurate statement, summary? Okay. Given that you're not an engineer or geologist, you haven't been qualified, what's your basis then for making the statement that incremental reserves are going to be left behind by not co-developing the A and the B?
All of my conversations with the subsurface team.
Okay, but that wasn't referenced in this paragraph, right?
Correct.
So if we just continue on, Powderhorn's proposal will forfeit cost savings achieved through economies of scale that favor Marathon's development. And did you provide Powderhorn or the division with any documentation of these cost savings that are going to be achieved through what you refer to as economies of scale?
I don't believe so.
Did you conduct any sort of comparative analysis?
I did not personally.
So then what would you say is the basis for your statement there in paragraph 17?
All of my collaboration with the subsurface teams.
So Mr. Rankin stated for the first time that I'm aware of, and I do think this is relevant to the case, that none of the proposals made to Conoco were economic. Do you remember that statement?
I'm sorry, where is that?
Hold on, there's going to be an objection. I sense it coming.
Well, I think I know what he's trying to get at, but I don't think it's exactly what I said. I'll say, I believe what I said was that none of the carry offers made by Powderhorn reached or met the level that Marathon would achieve by drilling its own acreage.
And that was made during your opening statement.
Correct, yeah, yeah.
Okay, so Mr. Holliday, please don't use, you use evidence, but don't use opening statement verbiage to base a question on. So find some other way to ask it. If you can.
I'll try this. Do you broadly agree with that statement?
I'm sorry, what's the
Do you
statement?
agree with Mr. Rankin's statement?
The opening statement?
Yes.
Yes.
But did you provide any analysis or data that the division could rely upon to verify that statement?
Thought we provided testimony, well, the reservoir engineer provided testimony.
But you didn't provide any
I did not personally provide.
to support your testimony.
I do not have an exhibit to support.
I just got 3 more questions, I think. Is it possible for a carry that requires no capital exposure on behalf of Conoco? Is it possible for that to be uneconomic?
I don't know. I'm not a reservoir engineer.
If you were to receive a non-cost bearing interest, like an override, and a well was drilled, is it possible for that to be non-economic?
Well, an override's different from just a straight carry. So I'm sorry, I can't answer that.
Okay. And last, I'm just talking about your testimony here. You stated that Conoco determined that drilling 1 mile wells was better than Powderhorn's development plans, but you didn't support any sort of, submit any sort of economic analysis or data to support this, did you?
I did not.
That's all my questions.
Okay.
Mr. Fordyce?
Good afternoon, Ms. Klingler. I just had a couple of follow-up questions. If we could look at, I'm going to refer to Exhibit A8 on page 60 for a moment. So Powderhorn engaged Marathon about this 960 acre unit they were trying to put together in July of 2025. Is that accurate?
I believe so.
Do you recall if or when this particular split the baby option might have ever been proposed or discussed with Powderhorn?
Yes, I discussed it with the co-CEO and I did mention it to Mr. Maka.
And as we've touched on, there were some initial proposals from Marathon for 1.5 mile wells in the north half of this proposed Powderhorn unit that would have required a pooling Powderhorn. Is that correct?
That's correct.
I believe that you said earlier that at some point Marathon had felt that it was just a better option for each majority interest owner to develop their own separate acreage depicted here in, like, we'll say 320 acre tracts. Marathon just decided it would be, like I said, better for each majority interest owner to develop their own acreage. Is that fair to say?
Yes, sir. I said we thought it would be fair and reasonable to allow each party to develop their acreage.
So would it also then be fair to say that this option and Marathon's final basically proposals or the APDs that were approved for the 1 mile wells in the north half, that would it be fair to say that that had more to do with how the interest was broken up in this acreage and maybe a little less to do with some of the other topics that we've discussed in this hearing, like parent-child effects or development sequencing?
The 1 mile option was considered to provide more value to us And it included being able to develop the A and C at the same time because we knew that was executable here.
Okay, thank you, Ms. Klingler. I have no further questions.
Yes, sir.
Mr. Rankin, is there any redirect?
Just a little, just a little. Mr. Holliday asked you some questions, Ms. Klingler, about whether or not Marathon would be under any time constraints if it were to drill its wells under the Marathon JOA. Do you recall that testimony?
Yes, sir.
And I think you gave an answer, but I want to make sure it's clear for the record. And I've highlighted here the language I think that governs your obligations under the Marathon JOA and would require you to, as it states here, complete with due diligence. Is that your understanding as well?
Yes, sir.
So while there's not a hard deadline, there's nevertheless an obligation to complete the project with due diligence, correct?
Yes, sir.
And it was your testimony that Marathon had commenced that work already, correct?
Yes, sir.
And in terms of enforcement, holding Marathon accountable, while it's not subject to the division, would you agree that the parties to the JOA would have the ability to hold Marathon accountable to this time, to the reasonable timeframe under this JOA?
Yes.
And that would include Powderhorn now as well, correct?
Yes.
You were asked some questions about some of the wells that were drilled nearby, I think by Admiral and maybe others, but I can't recall. Just, and again, for clarification of the record, I want to make sure it's clear that were those wells planned before Marathon had acquired the pilot test data that's been referenced in this case?
I'm sorry, which wells?
Well, I'm not sure exactly. Were they the wells that Mr. Holliday was asking about? It may have been the War Pigeon and maybe the Bat Bomb. Were those wells planned before you Marathon had received the data and the learnings from the pilot tests?
That is correct. They were planned prior to that.
Are there also other considerations in those cases or wells that either required or Marathon to drill only the Wolfcamp A in those circumstances?
We had timing constraints. We had obligations we had to meet, or obligations that had to be met.
Mr. Holliday asked if Marathon was the sole objecting party to Powderhorn's proposal. You recall that
I
question?
recall. Yes, sir.
And in fact, while you're the sole objecting party, Marathon is the 55% working interest owner in the north half of Section 2. So it owns the majority interest in some of the tracks that Powderhorn is seeking to develop, correct?
That's correct.
There was some discussion or questions from Mr. Holliday about delays from when the Powderhorn well proposals initially went over to Marathon. And you advised that you are the one in charge of this acreage, but when Powderhorn initially reached out, did they initially reach out to you?
No, sir.
And is it your opinion that because they didn't, there was a bit of a delay in the ultimate response from your company
Yes,
to Powderhorn?
Yes.
And once you got the package and the proposal, then things started kicking off, correct?
Yes.
Mr. Holliday asked you about Mr. Maka's testimony that Powderhorn had delayed filing its application for hearing on the October hearing date to the November hearing date. And he suggested it was due to negotiations with or in consideration of Marathon. You recall that question?
Yes, sir.
But there were other parties that Powderhorn was actively negotiating with, including Coterra and Avant, correct?
That's correct.
And at that time, they had not yet reached agreement with those parties, correct?
Correct.
And they hadn't reached agreement, in fact, didn't end up reaching agreement with those parties until right before the date for this contested hearing in which those parties were also going to be contesting Powderhorn's proposed development, correct?
That's correct.
So I mean, it seems like they would have continued the case, not just for consideration of Marathon, but for those other parties as well.
Yes, which was the basis of setting up the three-way split the baby option.
I think this came through in the dialogue, but it was a little bit messy in the record. And so I want to just take an opportunity to try to clean it up. I think I understood your testimony during the discourse with Mr. Holliday about the difference between what Powderhorn was doing by not initially disclosing that they didn't own the acreage offered for trade and you're still working through the approval process. And I think I just want to make sure I understood, and you can tell me if I'm wrong, but I understood that that your point was that Powderhorn didn't disclose that they didn't own the acreage, but you had disclosed that you were working through the management hurdles. Is that fair to say?
Yes,
And finally, that Marathon actually did own the acreage that it was proposing to trade, correct?
yes, sir.
You were asked some questions about the fact that you partnered with Admiral to drill a well in New Mexico where Admiral had never drilled a well before. And asked whether that was any different than what Powderhorn's proposing to do. You recall those questions?
Yes, sir.
Now, in fact, you mentioned that Admiral was working with Marathon or ConocoPhillips in Texas, correct?
Yes, sir.
And tell me just a little bit about that process. In fact, ConocoPhillips has been working with Admiral for some time, correct?
Yes, sir.
And explain to me just real quickly the process that Marathon and ConocoPhillips goes through in order to retain a contractor as a partner for drilling Marathon or ConocoPhillips wells.
We have a multi-layered vetting process. We have to market our projects. We're not allowed to just pick a designated operator. We have to market it, evaluate all of the offers that we receive or bids, sometimes called bids, the offers are called bids. And then when we determine that an offer is going to add value to the company and the beneficiaries of the state lands or the federal lands or the fee lands, we then start our vetting process as to a deep dive on the company that we're working with. Admiral in particular brought in their entire technical team, but it was several months after we did other due diligence and deep dives into them and their executive team and also understanding how they were working with us in Texas and watching those results.
And just so I'm clear, that the drilling that goes on when you use contractors like Admiral, is it according to Admiral's dictates or is it according to ConocoPhillips dictates about how the well is going to be drilled?
In the case of Bat Bomb and War Pigeon, it was collaborative. So they did present their plan. We presented our plan. We asked for tweaks to be made. Tweaks were made to their plan to satisfy our subsurface team and our managers.
And if Admiral didn't agree to what?
Mr. Rankin.
Yeah.
This is redirect, and I feel like the scope of the redirect is
Fair enough. I'll leave it
not
there.
being adhered to.
Well, I mean, I'll leave it there. I understand we're short of time, so I'll leave
We
it
do
there.
have one witness left. He's
I
been
understand.
very patient.
He has been. In fact, I think that was my last set of questions anyway. I have no further questions for Ms.
Thank you. May this witness be excused?
She may.
Thank you. Thank you, Ms. Klingler. Please call your last witness.
Thank you, Mr. Hearing Officer. Last witness is Mr. Preston Dupree.
Mr. Dupree, would you turn the microphone on? Thank you. And I remind you that you're still under oath from yesterday.
Yes, sir.
Mr. Dupree, will you please state your name for the record?
Preston Dupree.
And by whom are you employed and in what capacity?
I'm employed by ConocoPhillips, which is a subsidiary of Marathon Oil, and I'm a petroleum geologist.
Might it be the other way around?
Other way around, my apologies.
Okay, so you're employed by ConocoPhillips, which is owns
Owns.
Marathon as a wholly owned subsidiary. Okay. Is your testimony in this case marked as Exhibit B?
Yes, it is.
And have you conducted a study of the geology and the subject lands at issue in this case?
I have.
And you prepared your testimony marked as Exhibit B, along with Exhibits B1 through B5?
Yes.
And you also prepared rebuttal exhibits that include Exhibit B5 and B6. I'm sorry, Exhibit 5 and 6.
Yes.
And were those exhibits in your testimony prepared by you or compiled under direction and supervision?
Yes.
Any corrections or changes to the testimony exhibits that were filed?
No.
Do you adopt the testimony in the self-affirmed statement marked as Exhibit B as your own sworn testimony today?
Yes.
Mr. Dupree, I'm going to first ask you to address the vertical degradation arguments. Now, you're not an engineer, you're a geologist, and so I'm going to ask you to review what's marked as Exhibit 5 and share on the screen. Dr. Umekwe reviewed this yesterday as an engineer, and so I want you to just restrict your discussions to the geology. But if you would just start off and review for us the elements of the exhibit and focusing on the geology aspects.
Yes. So taking a look at this exhibit, starting off in the top left, it is a locator map of two different project areas. Starting off in the top left, northwest of that locator map, it's the Campana project, which also consists of the Super Hornet project from Powderhorn. And then moving to the southeast of the locator map is the internal ConocoPhillips pilot project of Potato Baby Keg Shell. Moving to the right of the screen, that is the Powderhorn proposed development plan. That's showing the gun barrel. Again, they're targeting the 4 Wolfcamp XY sand wells. And also sometime at a later date, they say they're going to come back for the Wolfcamp B. They call it the Wolfcamp B lower. However, for ConocoPhillips nomenclature, that is the Wolfcamp BC interface. Moving to the top right of the screen, that is the Potato Baby Keg Shell gun barrel showing the top-down versus co-development. So looking at the Potato Baby, that's the top-down development or sequential development, however you may want to say that. And then looking at the Keg Shell project, that is the co-dev where you're doing the Wolfcamp A and the Wolfcamp C together. Moving to the lower left portion of the screen, that is the 2-well cross-section that can be seen in the locator map from A to A prime. The first thing to note here, the stratigraphy of the area is similar enough to compare degradation concerns between the two areas. And from the geology witness from Powderhorn, he did not have any rejections to that. Starting off by looking at the A well or the first well, you can see that from the Powderhorn proposed well proposal that they sent us, there's a 610-foot vertical separation between the XY sand and what they call the Wolfcamp B lower. And then when you move to the right well or the A prime well where it's in Potato Baby Keg Shell area, there's a 724-foot vertical separation between those two landings. And again, when there's no significant geological variance between those upper and lower landings, you can compare those degradation concerns to look at production. And my counterpart, Dr. Umekwe, he mentioned this degradation plot yesterday, seeing that when you do this sequential development, you see that 19% degradation when you look at co-development.
Yeah, so just to be clear, the orange line would be the pilot tests portion that was done sequentially.
Yes, the orange line would be the sequential Potato Baby, and then the orange, and then the blue line above that would be the co-development Keg Shell project.
Mr. Dupree, there's some discussion about whether the distance between this pilot project location to the southeast of the Campana and Super Hornet project disqualifies this as a analogous project or test. What's your response to that?
When looking at the Potato Baby Keg Shell, I think this is a very well-confined, well-controlled project that is should be considered as a basis of looking at this top-down versus co-dev development plan. And then when you look at the lithology and the stratigraphy of the area, there is no geological concerns between the two targets that show any hindrance in the subsurface that may cause any kind of interference from fracture propagation.
So based on the geology, just to be clear and summarize, it's your opinion that there's no factor in the geology that would prohibit this test from being applicable to the Super Hornet or Campana acreage, correct?
That's correct.
Now, you heard some testimony about the landing zones were different, the well densities were different, but your response is the same. Is that fair to say?
Yes, the matter of problem here is not the landing zones that we're looking at. We're looking at depletion within the Wolfcamp Bay. And with that depletion in the Wolfcamp Bay, fracture propagation is going to want to move upwards from that Wolfcamp C development.
You mentioned something about a well-controlled project. There are questions from Mr. Ford, Examiner Fordyce, and others in this hearing about this particular project, about whether there could be other factors at play that might influence that degradation that's being observed between the portion of the project that was sequentially developed and the portion that was co-developed. Can you explain a little bit about why that isn't the case and the whole purpose of this test that ConocoPhillips undertook?
Yes, the whole purpose of this test was so we could develop our acreage in Eddy County to decide if we want to do top-down or sequential development versus co-development. And with this, we took out many outliers that went into the project. So I heard yesterday, or I think maybe it was earlier today, there were no shut-in wells that would have caused production differences. There was no, as far as I'm aware, completion sizes were modeled to replicate similar performance across the project areas. There was no outside abnormal anomalies that would have affected any kind of production between these two projects.
So in other words, while it wasn't a laboratory experiment where every single item could be controlled, the large ones were governed here and controlled by ConocoPhillips, correct?
That's correct.
Okay, and again, the purpose was so that you had a test that you could rely on in developing your acreage in this area.
That's correct.
Okay. I want to move on to Powderhorn's just allegations or claim about stranded acreage on a technical basis. And I think this was discussed a fair bit even prior before you getting up on the stand today. But I just would like for you to just review, you're familiar with the claim in Powderhorn's direct testimony that the northeast quarter of Section 3 would be stranded if Marathon were to develop its 1 mile wells in the north half of Section 2.
That's correct.
Based on that and your analysis, is there any technical reason, geologic reason, that Powderhorn's acreage in the northeast quarter of Section 3 would be stranded?
Geologically, no, that would be on their own doing.
If you would just review the slide here, Marathon Rebuttal Exhibit 6, just explain to us why, in your opinion, there's no preferential well orientation in this area.
Yeah, I'll just quickly rerun through this slide. I'm sure most of you are burnt out of it at this point. This is a well-published paper by Mark Zoback. He's very well-known across the industry. This is just the maximum stress orientation map that you can see in the black lines shown on the map. And then I tried to do my best to put their approximate AOI on there as well to show the reference that we're looking at. And then looking at the images to the right, the first one, it's the producing wells pre-2017. That's showing all the landing zones. And then the one on the farthest to the right is the producing wells 2017 and onward. And when you look at well orientation by vintage of years, pre-2017 and post-2017, there is no preference to stand up or lay down well orientation.
And in fact, Powderhorn's own exhibits reflect the same phenomenon, correct?
Yes.
And just to be clear, what does it mean that there's no preference for well orientation in this acreage?
You can either drill a stand-up well or a lay-down well.
And if Marathon's acreage happened to be positioned in Section 2, happened to be the west half of Section 2 rather than the north half of Section 2, would Marathon be proposing stand-up wells in that acreage?
Yes, it's the best way to develop our acreage.
Yeah, depending on your land position, correct?
Yes.
Okay, in this particular acreage, okay. Did you also review Ms. Klingler's rebuttal exhibits 1 through 4?
I did.
And do you see any problems with, on a geologic basis, with Powderhorn being able to develop the east half of Section 3 and the south half of Section 2 following any one of these proposed development plans?
No concerns.
In your opinion, Mr. Dupree, what's the best way to prevent waste and protect crowd rights in this contested case?
To let Marathon Oil develop their own acreage.
And that wouldn't prevent Powderhorn from developing its acreage, would it?
No.
Mr. Examiner, I have no further questions of Mr. Dupree at this time.
If we turn to paragraph 5 of your self-affirmed statement, you state, in my opinion, there's no substantial geological difference between the development plan proposed by Powderhorn and the development plan proposed by Marathon. Do you stand by that statement?
Can you show that to me on the screen?
Oh, I can if I share my screen.
Are you having trouble sharing your screen?
No, it's back up.
Would you share your screen? I mean, it is your exhibit and it's his own statement, so I'm not sure why we need to see it, but
Okay.
there it is.
Well, that's your statement, correct?
Yes.
So the geology does not favor Marathon's plan over Powderhorn's. Is that correct?
We are targeting the same intervals within the Wolfcamp.
Thank you. That's the answer to my next question, but geology doesn't favor one plan over the other. Is that correct?
Based on the landing zones, it is not.
And both Marathon and Powderhorn, they're proposing the same orientation, right?
East to west, yes,
Similar spacing, correct?
roughly.
And the only difference that you can identify, or that you do identify, between the Wolfcamp XY wells is lateral length, and that's 1.5 versus 1 mile. Is that fair to say?
That's correct.
So is there any geological impediment to drilling 1.5 mile wells in this area?
Can you rephrase that?
Is there any geologic impediment to drilling 1.5 miles in the acreage we're discussing, sections 2 and 3?
Any geological reasons? No.
And the Wolfcamp formation, you think it's continuous across both sections, is that
That's
correct?
correct. Yeah.
Okay. So in a hypothetical, I know that Marathon wants to drill the north half, section 2 only. But would the geology support a single spacing unit then covering both sections?
North half and south half, is that what you're referencing?
Yeah, the full 960, or yes, the full 960 in Powderhorn's plan.
Can you rephrase that? Sorry.
Sure. Does the geology, and yeah, same thing I told Ms. Klingler, if I, not trying to trip you up,
Yep.
just ask for clarification. Does the geology support a single spacing unit covering the 960 acres proposed by Powderhorn?
I think it matters based off acreage, off your owned acreage. I don't think that's a geology question.
Okay, so there may be economic reasons, working interest wise, that your answer would different, but if we're just looking at geology, the geology would support a single spacing unit covering both sections, correct?
It could cover both spacing units as well.
Right. Okay, so well, we don't need to recite your testimony. What do you estimate is the stress orientation within the 960 acres proposed for the Super Hornet?
It's hard to give an exact measurement there since it's such a wide, based off that image, it is a wide view at the Permian Basin, but it's roughly northeast 40, I would say.
Northeast 40?
Yes, sir.
If you could drill a well or this well at any orientation, what would your preferred orientation be?
Be based off the acreage that I own.
If you could drill a well within the proposed 960 acre Super Hornet spacing unit, what would be your preferred orientation?
Since our acreage is east to west, I would do east to west.
Would that be a geologic reason or a working interest reason?
I don't think either of those apply.
So you mentioned because your interest is in the north half of section 2.
Mhm.
Is that the basis for your preferred orientation, or is it a geological basis for your preferred orientation?
It's the best way to develop our acreage.
Geologically.
Sure.
If we go to Marathon Exhibit 6, I believe that's contested. Exhibit 6. And these wells, these wells in the bottom right corner. How were these wells selected?
Which image are you referring to? To the top right of the screen?
The right of the screen.
How were they selected? Oh,
Yes.
Can you
How were the
clarify?
wells on the far right graph, or, excuse me, picture? How were they selected?
selected based off a public database in Veris. They were chosen by producing wells 2017 and onwards and filtered by all the landing formations in the area.
To your knowledge, is there a reason why 2017 was used as a cutoff for this exhibit?
It's usually common practice to use 2017 and onward as a modern well.
Can stress orientation change over a 20 to 25 mile space within the Delaware Basin?
To what degree? Oh, can you clarify to agree?
Just can it change?
It can rotate.
And I don't want to do a full deep dive on this. I don't think anybody wants me to. Are wells always oriented due to maximum stress, or do operations and ownerships sometimes influence orientations we've discussed previously?
Mostly primarily due to the acreage that you own.
So it would be ownership more than maximum stress. Is that correct?
It goes both ways. You can't just choose one or the other. Sometimes there is preferential based off maximum stress. But the leading driver is based off the acreage position that you have.
Is counting the wells drilled over a 400 square mile area in 2 separate time periods, is that a key part of how Conoco determines the optimal stress? Or do you typically and primarily rely on other data?
Gives a good representation of the area and how reputable operators have drilled their wells.
If we go up to this is exhibit 5. Did you select and review the logs that are exhibited here, comparing the Super Hornet to the Potato Baby?
I did.
And do you know approximately how far apart the 2 logs are?
2.5 townships, give or take.
20 miles approximately?
Let's just go with that.
And the Potato Baby Wolfcamp A is targeting the same landing plan for the Wolfcamp A and the Super Hornet, right?
Say that again.
Are the Potato Baby Wolfcamp A wells represented here? Are they all targeting the same landing planned for the Wolfcamp A in the Super Hornet?
Super Hornet's targeting the XY. We're targeting the Wolfcamp A and Potato Baby.
Okay. Is the difference between the Wolfcamp A and what you're calling the Wolfcamp XY, is that just a phrase, or do you think there's some material difference?
There's a material difference between faces. Yes.
Are the Potato Baby deep wolf camps, so now we're moving to the B and C, are they all targeting the same landing that's planned for landing the deep wolf camp wells in the Super Hornet?
I would say half of them are.
Looking still at the Potato Baby, it was developed at a similar well spacing to the Super Hornet. Is that right? Or the plans for the Super Hornet?
Approximately.
In your opinion as a geologist, does well landing in proximity to other wells, does that have an influence on the production of an individual well and how it interacts with other wells?
Can you rephrase that?
So the 2 factors, well landing, where you well the land the well, and then its proximity to other wells. Does that have an influence on production for an individual well?
I can speak to the landing part first. The landings that we're talking about here in Potato Baby versus Campana or Super Hornet, as you may reference. I do not think that the argument at question is the landings of the wells. It's more about the depressurizing the wolf camp while you're doing top-down degradation. That's what this learning is about.
Does the proximity to other wells, does that influence how it interacts with other wells?
The proximity we just agreed on is similar to what you're doing in Super Hornet.
So would you agree that parent-child effects, those are interactions between wells? Is that accurate?
That's part of it.
Now, it looks on here like you show a gamma ray log, a resistivity log, density porosity, and then neutron porosity for each well. Is that right?
That is correct.
And would you state that the Potato Baby and the Super Hornet logs that you've reviewed, do they have similar or very similar readings for each of these logs within the interval identified by the red arrows on this slide?
I would say so.
Okay, so no substantial differences?
That's correct.
Do you believe the lithology in the Potato Baby and the Super Hornet, do you believe those to be substantially similar?
There may be slight variations, but nothing to denote the degradation concerns between those two landings.
So based on the geologic data that you presented and the research you've done, do you believe that reservoir properties such as porosity, permeability, pressure, hydrocarbons in place, are they substantially similar in the area identified by the red arrows within the Super Hornet and within the Potato Baby?
I would say so.
So these same factors, porosity, permeability, pressure, hydrocarbon in place, does that have an influence also on the interaction between wells?
Clarifying question, can I ask? I would say some of those parameters that you mentioned.
Some of the so is there one of the, if we look at porosity, permeability,
Mhm.
reservoir pressure, and hydrocarbon in place, do those four things have an influence on interactions between the wells?
I would say so.
Yes. Okay. So then would you again agree that parent-child effects, these are interactions between wells?
Between wells in the same unit do not apply to wells in separate spacing units.
So you would not agree?
Depends on how you ask.
So we talked about, I think it was your testimony that those four factors do have an influence on the interactions between wells. Is that accurate?
I'd say some of the specific parameters that you mentioned, yes.
Which of them do not?
I would say the porosity and permeability are the main factors there.
I just want two more questions real quick. If we go to paragraph 8 of your statement. And I want to talk about this sentence. Okay. So you say here that Powderhorn's development sequence, it presents a risk of degradation to the B and C targets. Is that correct?
That's correct.
Would drilling the northern two Wolfcamp A wells in Powderhorn's proposed 960, so are you with me? Would it, let me rephrase that. Would drilling the two northern Wolfcamp A wells in Powderhorn's proposed 960 acre spacing unit separately from the southern two Wolfcamp A wells, would that present a risk of degradation?
I would say that's not your acreage yet. So you can't, that's a hypothetical.
Right. Okay. So in a hypothetical situation, if you were to drill two Wolfcamp wells in the northern half and then come back separately and drill two Wolfcamp wells in the southern half, would that present a risk of degradation?
Depends.
Depends on what?
You talk about operators, different operators drill wells differently. How in zone is this when you do drill it with your third-party contractor? What's your completion? I can't answer this because there are so many variables that go into it.
Fair to say you don't know?
Based off the hypothetical that you gave, yes.
So then, is it your test, and this is the last question, based on what we just said about the north half, south half, are you testifying that there is no risk of parent-child effects on two wells spaced 1,320 feet apart in the same landing?
That would be a reservoir engineering question.
Okay. Then, why were we talking about that here in paragraph 8?
This is top-down degradation. We're not talking about horizontal degradation.
But, okay, I'll just leave it there. No more questions.
Mr. Fordyce?
Now, Mr. Hearing Examiner, I have no further questions for Mr. Dupree.
All right, Mr. Rank, can we stop sharing the screen now? Mr. Holliday? Mr. Rankin,
I just have one question.
One,
From
go ahead.
Mr. Dupree. And this goes to the general questions from Mr. Holliday about preferences for 1 mile, 1 mile, 1.5 mile, whether, how he would prefer to drill. Mr. Dupree, to your knowledge, if Powderhorn reached voluntary agreement with Marathon under a JOA where Marathon would operate the north half of section 2 and the northeast quarter of section 3, would Marathon be willing to drill 1.5 mile laterals in that instance?
We would.
No other questions.
Does that raise any? No. Mr. Fordyce, did that question raise anything for you?
No, Mr. Hearing Examiner.
All right. Okay, do you rest your case in chief?
Thank you very much, Mayor. Yes.
All right. So both parties have rested their case in chief. Mr. Holliday, do you have any rebuttal?
For this witness?
Do you have a rebuttal case?
Oh, no, we stand on our.
Mr. Rankin, do you have a rebuttal case?
I do not.
Okay, excellent. Then the evidentiary record is closed. I'm going to reiterate that Mr. Holliday is going to submit an amended exhibit packet with a cover letter by April 10 is the deadline for closing arguments. When will you submit the amended exhibit packet?
And that's. The amended exhibit packet specifically, that's removing the NSL references that we talked about.
It's removing the NSL reference in exhibit A9. It's removing A18 completely. I believe, Mr. Rankin, am I missing anything?
I believe that was it.
I thought so too.
Yeah.
I think we have that already prepared, so I would say within the week.
Fine. So we'll say a week from today is your deadline for that. Please pass it by Mr. Rankin first.
Yes, sir.
Okay. So we talked about that. That includes a cover letter. We're going to remove your old exhibit packages. So that amended exhibit package should have your rebuttal exhibits, a table of contents and a cover letter. Okay. You don't need to amend anything. We'll leave yours as it is. I believe you have one exhibit packet and one rebuttal exhibit packet.
That's correct.
Fine. So there's nothing to amend there or change. We've talked about the transcript 2 weeks from today. Based on that date, we came up with 2 weeks plus 2 days for April 10 for a closing argument. That's a 10-page limit that does not include the caption page or the certificate of service page. Everything must be cited to the record or it won't be considered in your closing argument. Is there anything else that I've missed? No? All right. No? Okay, both parties have said no. Mr. Dupree, thank you for hanging around for 2 days to testify. I hope everyone has a good trip home. We're off the record. Thank you.